All right, so we have discussed, start ho gaya? All right, so we have discussed Article 368, Amendment of the Indian Constitution, right? So today we are briefly going to discuss about the criticisms of amendment procedure, okay? And briefly I am going to discuss comparison between the amendment procedure in India with that of USA, right? Because that is not there in any of the sources. And every year UPSC is asking question in mains about comparison of Indian constitution with the other constitutions, right? For example, they asked in 2 years back, I guess in 2019 or 20, I don't remember, but they asked comparison between the judiciary of India and UK. This year they asked the comparison between right to equality in USA and India. So similarly, they might ask the comparison between the amendment procedure in India and in USA. So that becomes a very important topic. Okay? So what are the criticisms? So the first criticism is that there is no special body for for making amendment to the Indian Constitution. Special body as in Constitutional Convention. Constitutional Convention or Constituent Assembly. In some countries like USA, there is a requirement of amendment of the Constitution of USA by a special body called as Constitutional Convention. In some countries, for amending the Constitution, there is requirement of convening the Constituent Assembly. But in India, there is no such body. Who has power to amend the Constitution in India? It is the Parliament, right? And the Parliament passes the ordinary laws, and Parliament makes the amendment to the Indian Constitution as well. So there is no special body or authority to amend the Constitution. The constituent power to amend the Constitution is given to the Parliament, right? Whereas in USA, there is a special body for the purpose of amending the Constitution of USA. That is called as Constitutional Convention. Yes, first. Then the second criticism is about, I have told you that power to initiate. Who can initiate the constitutional amendment bills in India? Who can initiate the constitutional amendment in India? Who can initiate? No, who can initiate? Whether it is a parliament or a state legislature? It is parliament. So power to initiate, just a second. Sorry. So power to initiate the amendment to the constitution belongs only to the parliament and not to the state legislature. State legislature can initiate amendment to the Constitution of India only in one instance. That is resolution passed by the state legislature for creation or abolition of the legislative councils in that particular state. Right? And even in that aspect, Parliament may approve or disapprove the resolution passed by the state legislature, or it may not take any action on that. So the point is, power to initiate amendment to the Indian Constitution lies only exclusively with the Parliament. State legislatures, they do not have any power to amend the Indian Constitution. They cannot initiate the process of amendment of the Indian Constitution, except in there is one exception about resolution to be passed by the state legislature by special majority, right, for creation or abolition of legislative councils. And even in this aspect, Parliament has to pass the law. Then only the legislative council can be abolished or created. Mere passage of resolution by state legislature doesn't matter. And even Parliament can approve that resolution, or it can disapprove the resolution, or it may not take any action on that. Whereas if you compare this with USA, in USA, even the state legislatures, they have power to initiate the amendment to the Constitution of USA. How? The Constitution of USA provides that if two-thirds of the state legislatures they petition they petition the Congress, that is legislature, central legislature of USA is called as Congress. So if 2/3 of the state legislatures petition the Congress, then Congress must call for constitutional convention for amending the Constitution of USA. Right? So if 2/3 of the state legislature petition the Congress, then constitutional convention has to be called by the Congress for the purpose of amending the US Constitution. So in USA, state legislatures have power to initiate the process of amendment. Ultimate amendment is done by constitutional convention, but at least they can initiate the process of amendment. Whereas in India, state legislatures cannot initiate the process of amendment to the Indian Constitution except in one instance. And that too, there are limitations, right? This is the second thing. And simultaneously understand the difference between US amendment procedure in USA and India. Okay, in USA, there is a constitutional convention, separate body, special body. But in India, it can be done by parliament alone. There is no provision for special. This is the first difference between India and USA. Second is this. Okay, right? Now third, so this is the criticism. There is no state legislature. We are a federal country. We are a federal country, so even state legislatures should have power to initiate the amendment to the Indian Constitution, which they do not have currently. So this can be the criticism. Then third is that the majority of the Indian Constitution can be passed either by a special majority or by a simple majority. Only in few cases, the constitutional amendment bill is to be ratified by the state legislatures. Majority, I repeat, majority of the provisions of the Indian Constitution can be passed either by a special majority or by a simple majority. Only in few cases, the ratification of state legislature is required, and that too not all state legislatures, only half of the state legislatures. Right? So only few constitutional amendment bills which affect the federal structure, they require the ratification of state legislatures, and that too not all, only half of the state legislatures, and by simple majority. Whereas in USA, countries like USA, every constitutional amendment bill after being passed by both the houses of Congress has to be ratified by at least 3/4 of the state legislatures. Every constitutional amendment bill, and not only those bills which affect the federal structure. In India, I told you about the 8 provisions of the Indian Constitution which related to the federal structure of Indian Constitution. If they are to be amended, they require not only the special majority in both the houses of parliament, but also ratification of not less than half of the state legislatures. I have told you about those 8. Remember those 8, right? Election of the president and its manner, then representation of states in parliament, so on and so forth. These are the 8. GST Council, right? But in USA, every constitutional amendment bill has to be passed not only by both the houses of Congress, but also by 3/4 of the state legislatures. In India, only few constitutional amendment bills require ratification of the state legislation, and then that too only half. Here, every constitutional amendment bill has to be ratified by 3/4 of the state legislature. There are 50 state legislatures. There are 50 states in USA. There are 50 state legislatures. So, out of 50, 38 state legislatures has to ratify the amendment to the amendment bill to the Constitution of USA. This is the difference. In India, not all the constitutional amendment bills require ratification of the state legislature. Only few, and that too only half. Here, the requirement is every constitutional amendment bill, and that too 3/4. Got it? Clear? Fine. Now, the next is, there is no time limit prescribed for the state legislatures to ratify the constitutional amendment bills passed by both the houses of parliament. Is there any time limit within which the state legislatures have to pass the constitutional amendment bill? There is no time limit. So once both the houses of parliament pass the constitutional amendment bill which affect the federal structure, those bills will be sent to, that particular bill will be sent to 28 state legislatures in India. Now there is no time limit within which they have to ratify such constitutional amendment bills. They can ratify, they can take their own time. So this is also, this might delay the amendment to the Indian Constitution. So there must be some time limit, be it 1 month, 2 months, 6 months, 1 year. There should be some time limit within which the state legislatures have to ratify the constitutional amendment bills passed by both the houses of parliament. But currently there is no such time limit. So this is the criticism, right? Okay. Now next criticism is that, you know, there is, I told you that every constitutional amendment bill has to be passed by both the houses of parliament separately, right? And if any one of the houses, it does not pass the constitutional amendment bills, then that constitutional amendment bills, they lapse. They cannot become an act. So there is no provision of joint sitting to resolve the disagreement or resolve the deadlock that might arise between both the houses of parliament, right? So whereas in case of ordinary bills or financial bills, there is a provision of joint sitting. So critics argue that there should be a provision of joint sitting, like in case of ordinary bills or financial bills, to resolve the deadlock, but currently there is no provision of joint sitting, right? So these are some of the main criticisms of India's amendment procedure provided by Article 368 of Indian Constitution. Okay? Now coming back to our discussion on comparison between the amendment procedure in India and that in USA. So first point you should write is that in India, Article 368 provides for amendment of the Indian Constitution. Okay? Whereas in USA it is Part 5. Okay? In India it is Article 368. In USA it is Part 5, which provides for procedure of amendment procedure. This can be the first difference. Then second difference is about Constitutional Convention. There is a separate body that is called as Constitutional Convention in case of USA. In India it can be done by Parliament. Then third, in India power to initiate the constitutional amendment bill lies only with the Parliament. State legislature cannot initiate. Whereas in USA, if 2/3 of the state legislature they petition the Congress, US Congress, then the US Congress must call for Constitutional Convention. So state legislatures, they have power to initiate amendment to the US Constitution. This power does not belong to Indian state legislatures, right? There is only one exception. The next difference is that in India, only few constitutional amendment bills which affect the federal structure of the Indian Constitution require ratification of the state legislatures, and that too only half of the state legislatures. Only in few cases. Whereas in USA, all the constitutional amendment bills has to be ratified by not half, but by 3/4 of the state legislature. Here only few, and that too half. Here all the constitutional amendment bills, and that too 3/4 of the state legislatures. 38 out of 50 state legislatures. This is the difference. Okay? Then the next and the final difference we can say is that in India, every constitutional amendment bill, when it is duly passed by both the houses of parliament and whenever required by the ratification of the state legislature, such constitutional amendment bill will be sent to the President of India for ratification. For consent. For consent. No, not consent, for assent. This is the technical term. Okay? And no constitutional amendment bill can become an act without the assent of the President of India, like in India. But in USA, President of USA has no role to play in amendment to the Constitution of USA. The moment US Congress and not less than 3/4 of the state legislatures of USA, they pass the constitutional amendment bills, there is no requirement of bill being ratified by bill to be ratified by the President. Okay? So next difference is, please write down all these differences. These are not given anywhere in Lakshmikant or any other book. These differences are very, very important, right? So in USA, President does not play any role in enactment of the amendment to the US Constitution. Whereas in India, no constitutional amendment bill can become an act without the assent of the president. Okay? And you can also write down one more criticism of the amendment procedure in India. That is, that President of India have no veto powers when it comes to the constitutional amendment, giving assent to the constitutional amendment bill. So this can also be a criticism, that the original Indian constitution provided for veto power for the President of India when it comes to constitutional amendment bills. It was 24th Constitutional Amendment Act 1971, which made it constitutionally binding on the President to give his assent on the constitutional amendment bills. So this can also be the criticism, that why should the President should enjoy veto powers. Okay? So these are some of the criticisms of the amendment procedure, and this is the comparison between the amendment procedure in USA and amendment procedure in India. Believe me, there might be a question in UPSC mains regarding this. Compare and contrast the amendment procedure to the constitution in USA and India. Or there might be a prelims question. Consider the following statements regarding amendment to the constitution of USA and India. Number 1, number 2, number 3 statements. Which are the following statements are correct, incorrect, whatever it may be. Right? Now you are in a position to answer the questions. Right? Fine. Now, despite of these criticisms of the amendment procedure, the amendment procedure provided by Indian Constitution have fairly been successful in the sense that the amendment procedure in India is not flexible, not that flexible as in case of UK, to allow the ruling party to change the constitution as per its whims and fancies. It is not easy. The amendment of the Indian procedure is not so easy, or it is not so flexible as in case of UK, so as to allow the ruling parties to amend the constitution based on its whims and fancies. And the amendment procedure is not that rigid as well, to prevent the constitution from changing in accordance with the needs of times and circumstances. So the amendment procedure in India is neither flexible as in case of UK, and it is not, nor it is rigid as in case of Constitution of USA. It is very rigid. One of the point of differences you can write down in comparison, that the process of amendment of US Constitution is extremely rigid, whereas in case of India, the process of amendment of the Indian Constitution is neither flexible nor rigid. It strikes a proper balance between the rigidity and flexibility, as argued by K.C. Weirs. He was a renowned constitutional expert. He argued that the amendment procedure in provided under Indian Constitution is neither flexible nor rigid, but it strikes a proper balance between rigidity and flexibility. Okay, right? Then you can quote some people. While there might be a question, critically analyze the amendment procedure provided under Article 368. There might be a question on mains. So here you can quote Jawaharlal Nehru. Remember, in the beginning of the lecture, I told you about the views of Jawaharlal Nehru. Jawaharlal Nehru, he talking about the amendment procedure under Article 368, he said that while we want the Indian Constitution to be as solid and permanent as it can be, as we can, but there cannot be permanence in the Constitution. There has to be some degree of flexibility. If you make the Constitution rigid, inflexible and permanent, then it means that you are stopping the nation's growth. Right? And the amendment procedure provided under Article 368 takes care of this, to prevent the Constitution of becoming too rigid and permanent. Right? Okay? Then Dr. B.R. Ambedkar, you can write down about the views of Dr. B.R. Ambedkar. He defended the amendment procedure, some of the members of Constituent Assembly, they criticized the amendment procedure provided under Article 368 while they were discussing Article 368, debating Article 368. He said that the draft the Constituent Assembly, or the draft constitution prepared by the drafting committee of which Dr. B.R. Ambedkar was chairman, it has refrained from putting the seal of finality or infallibility on the Indian Constitution. And he argued that we have allowed the Constitution of India to be amended, to be adopted in accordance with the changing needs of times and circumstances. We have allowed the procedure provided under Article 368 allows the future generations to amend the Indian Constitution as per their own requirements, as per the needs of times and circumstances. Okay? Then you can also write down about arguments of K.C. Weir's. K.C. Weir was very impressed with the variety of the constitutional amendment procedure provided under Article 368 as well as outside Article 368. Right? See, in India, the Constitution can be amended in 3 ways. Number 1, amendment by simple majority of the Parliament. Second, amendment by special majority of the Parliament. Third, amendment by special majority of the Parliament and ratification of not less than half of the state legislatures. So there is variety of amendment procedure. And he says that this variety of amendment procedure is wise and it is rarely found. It is rarely found in other countries. Okay? Then Granville Austin. You can also write down about Granville Austin. Now Granville Austin, he was a great admirer of Indian Constitution. He wrote one book, Indian Constitution, Cornerstone of a Nation. A very famous book. Those who have political science as an optional subject, they must read this book. Not reading the book, but you must read the summary of this book. Indian Constitution, Cornerstone of a Nation. This book was published in 1966, and he praised, in that book, he praised the amendment procedure provided under Article 368. He said that the amendment procedure under Article 368 is one of the ably conceived provisions of the Indian Constitution. One of the best provisions of the Indian Constitution is Article 368. And he argued that it might appear, the procedure of amending the Indian Constitution under Article 368 might appear to be complicated, but it is merely diverse. It is not complicated. It is just that it is diverse. And diversity is a good thing. Right? So this is how you can summarize your answer. If there is a question, critically analyze the amendment procedure under Article 368. So first you will write down the criticisms. Then you will write down about views of Jawaharlal Nehru, Ambedkar, K.C. Weir's, and then you can write down that in the conclusion you can write down that Indian Constitution is neither too flexible like Constitution of UK to allow the ruling party to change the Constitution as per their whims and fancies, because UK Constitution can be changed as per the whims and fancies of ruling parties, because it requires only simple majority. It is neither rigid like in UK Constitution. It strikes as rightly argued by K.C. Weir, it strikes a proper balance between the rigidity and flexibility. And this procedure has been very successful. The Indian experience in past suggests that the procedure of amendment under Article 368 has been very successful. One of the successful provisions of the Indian Constitution. Nobody has criticized Article 368. Very few people have criticized Article 368. Yes, there are some criticisms. Right? There are some criticisms, but despite these criticisms, the Article 368 has served us very well. So you have to end your answer in a positive tone. Got it? Okay. See, amendment to the Indian Constitution is one of the most important topics for UPSC, both prelims as well as mains. You know, when I gave my interview in UPSC, I was asked about procedure of amendment of the US Constitution. They might ask anything, you know. It is not necessary for you to be a student of particular discipline. So it is very important, and every now and then they might ask you about basic structure doctrine, or Article 368 comparison, so on and so forth. So prepare this topic very carefully. Okay, got it? Fine. That you will get from the Lakshmikant. Okay? All these arguments are already. Which book? This Granville Austin, na? वो Lakshmikant, Indian Constitution, Cornerstone of a Nation. See, just focus on understanding. All this content you will get from Lakshmikant, but today you are you should have written you must write the comparison between Indian and US Constitution. वो उसमें नहीं दिया हुआ है, तो आपको लिखना है, ठीक है? Right? चलो, now let us discuss next topic, judicial review. Again, very important topic. Very, very important topic. Okay? Here I am going to discuss in detail meaning of judicial review, okay? The importance of judicial review, the scope of judicial review. Then we will also compare the scope of judicial review in USA and in India. Okay? And then in the end we are going to discuss the judicial review of the 9th schedule of Indian Constitution. And in that context, we are going to discuss one of the landmark cases of Supreme Court, that is I.R. Coelho versus State of Tamil Nadu, 2007. This is what we are going to study. So let's begin. Judicial review. Now, the doctrine of judicial review, from where it originated, from where this concept came, it is very, very important to understand. So, doctrine of judicial review, it originated and developed in USA. Yes, the doctrine of judicial review originated and developed in USA, United States of America. And we know that which is the oldest constitution in the world? USA. When it was when it came into force? 1789. Remember this year. Now, interestingly, Constitution of America nowhere empowers the judiciary, Supreme Court of America, power of judicial review. Nowhere it empowers the judiciary to review the laws and enactments of the executive and the legislature. The power of judicial review is nowhere mentioned in Constitution of USA. Then how it originated, how it was developed? This might be the next question, right? So, the doctrine of judicial review or the principle of judicial review was propounded by the Supreme Court of USA. The Supreme Court of USA for the first time propounded or gave the doctrine of judicial review in a very famous case in US constitutional history known as, write down this case, Marbury versus Madison, 1803. The doctrine of judicial review was propounded in a very famous case known as Marbury versus Madison case of 1803. And this doctrine was propounded, or it was given by John Marshall, who was the then Chief Justice of US Supreme Court. Yes? So, let me sum up for you. Okay? Doctrine of judicial review originated and developed in USA. It was propounded in a very famous case known as Marbury versus Madison, 1803. By who propounded this doctrine of judicial review? John Marshall. Who was John Marshall? The then or the former Chief Justice of American Supreme Court. American Constitution does not provide for judicial review. So in America, judicial review is judicial innovation. In America, judicial review is a result of judicial innovation or judicial interpretation, right? It is nowhere provided in the Constitution. Got it? But in India, the Indian Constitution itself empowers higher judiciary, that is Supreme Court and 25 high courts, the power of judicial review. But even in case of India, the term judicial review or the doctrine of judicial review is nowhere mentioned directly, explicitly in Indian Constitution. Like the word federation or federalism is nowhere used in the Indian Constitution, but Indian Constitution is federal. Similarly, the doctrine of judicial review is not explicitly mentioned that one article of the article XYZ judicial review. No. But there are some articles, some provisions of the Indian Constitution which explicitly provides for power of judicial review. Got it? For example, Article 32. Then Article 226. Yes, what is your question?
But sir, in US nowhere mentioned about judicial innovation or judicial interpretation.
What?
Sir, Indian Constitution में explicitly mentioned है.
No, the term judicial review is nowhere mentioned in the Indian Constitution.
Term mentioned नहीं है.
Yes, the power of judicial review is explicitly conferred by the Indian Constitution. It is not propounded by the Supreme Court of India like in USA. Got it? But the term judicial review is nowhere mentioned in the Indian Constitution. But the power of judicial review has been explicitly conferred by the Constitution of India itself, unlike in USA. In USA, this doctrine was propounded by Supreme Court of USA. It is a result of judicial innovation or judicial interpretation. Right? ठीक है, समझ में आया इतना? Fine. See, Article 332. It provides fundamental right of constitutional remedies. If any of the fundamental rights of the citizens are violated, then they can directly approach the Supreme Court. And Supreme Court will use the power of judicial review to protect the fundamental rights of the citizens. So the power of judicial review is explicitly conferred by the Constitution of India under various provisions of the Constitution. Like Article 32, Article 226 is about power of judicial review of high courts. And there are other provisions as well. समझ में आया? ठीक है? When it comes to USA, the power of judicial review has not been conferred by the Constitution of USA. Whereas in case of India, the power of judicial review has been explicitly conferred by the Constitution of India through various provisions. But in both USA and in India, the term judicial review is nowhere mentioned. समझ में आया? ये टर्म जो होता है ना जुडिशियल रिव्यू, कहीं मेंशन नहीं किया है. जैसे फेडरलिज्म कहीं मेंशन नहीं किया है, बेसिक स्ट्रक्चर डॉक्ट्रिन कहीं मेंशन नहीं किया है. समझ में आया? वेरी गुड. चलो. Now, see why I am discussing judicial review in detail, because after that I am going to discuss evergreen or one of the most popular topics of UPSC, and that is basic structure doctrine. Basic structure doctrine was propounded by Supreme Court of India in a landmark case, Kesavananda Bharati versus State of Kerala, right? And this was the case in which Supreme Court of India used its power of judicial review. So you cannot understand basic structure doctrine without understanding judicial review, the concept of judicial review. And that is why I am teaching you. Okay, got it? So as told before, the Supreme Court of India have used the power of judicial review in number of cases. since commencement of the Indian Constitution. For example, Golaknath, IC Golaknath and others versus State of Punjab case of 1967, which we are going to study when we are going to discuss basic state doctrine. Then bank nationalization case 1970, okay? Abolition of privy purses case 1971, case 1 Ananda Bharati case 1973, I already told you. Minerva Mills case 1980, so on and so forth. So Supreme Court of India in number of cases have used its power of judicial review. You know, the recent example wherein judiciary used power of judicial review was when judiciary declared 99th Constitutional Amendment Act 2014 and National Judicial Appointments Commission Act 2014. Both 99th Constitutional Amendment Act 2014 and National Judicial Appointments Commission Act 2014, they were declared as unconstitutional and null and void by the Supreme Court of India in 2015. Got it? What is this? We are going to discuss when we discuss Supreme Court. So Supreme Court of India, since commencement of the Indian Constitution, has used this power in number of cases. Got it? The origin of the concept, where it originated, where it developed, USA, India. In USA, it is the power of judicial review is not explicitly conferred by the Constitution of USA. Whereas in India, the power of judicial review is explicitly conferred on Supreme Court and 25 High Courts. Got it? Clear? ये भी क्वेश्चन आ सकता है आपको, कंपेयर द पावर ऑफ जुडिशियल रिव्यू इन यूएसए एंड इन इंडिया. दिस माइट बी अ पॉसिबल क्वेश्चन. ठीक है. नाउ what is judicial review? The most important question, what is judicial review? Now what is the meaning of the term review? What is review? What? Cross examination. Review means assessment. Any kind of assessment or evaluation. The word review means any kind of assessment or evaluation. Now the next question is, of what? Of what and by whom? If you understand this, you will understand. Please don't interrupt. Okay? So review means assessment and evaluation. Of what? Of number one, legislative enactments, of parliament, in context of India, parliament and state legislatures. Number second, assessment and evaluation of what? Legislative enactments. What do you mean by enactments? Laws. Laws. Legislative enactments, laws of the parliament and state legislatures. Number one, assessment and evaluation of legislative enactments of the parliament and state legislatures. Second, the executive actions or executive orders or actions. Executive orders or administrative actions. Administrative actions of executive. Remember, now here comes in the concept. Okay? I'll tell you about that. Okay? So judicial review means a power of assessment and evaluation of what? Of what? Legislative enactments of parliament and state legislature and executive orders or administrative actions of whom? Executive. Okay? And who has this power? Who has this power? Now tell me, who has this power? Who will exercise? Power of assessment or evaluation, who? Absolutely wrong. यही तो दिक्कत करते हो आप लोग. हायर जुडिशरी. अभी तो बताया मैंने आर्टिकल 226 हायर जुडिशरी. ठीक है? ठीक है, ये हो गया. ठीक है, now it completes your definition. ठीक है, now I will tell you the exact definition. Review means assessment and evaluation. By whom? By higher judiciary, Supreme Court and High Court in case of India, meaning lower judiciary. District courts and subordinate courts, they do not have power of judicial review. Power of whom? Higher judiciary. Of what? Of what? Of examining the constitutional validity. Of whom? Assessment and evaluation of what? Legislative actions, actions of legislature and executive, not judiciary. So judiciary cannot use the power of judicial review to assess and evaluate its own actions, but it can, but under different powers. So remember, तो UPSC आपको confuse कर सकता है. Judicial review is a power of higher judiciary to number one, number one, examine the constitutionality of number one, laws passed by the legislature, number two, orders of the executive, number three, judicial judgments. So will judicial judgments, review of judicial judgments will come under the judicial review. Got it? So judiciary, higher judiciary can use power of judicial review to examine the actions of legislature and executive only. But it does not mean that judiciary in India, higher judiciary in India cannot cross-examine its own actions. It can, but not under the power of judicial review. समझ में आया? Now write down the definition of judicial review. Write down. Judicial review is, good afternoon Shubham Saini, good afternoon to all of you. Judicial review is the power of higher judiciary to examine what? To examine. क्रॉस करके लिखो एग्जामिन, और क्या कर सकते हो आप यहां पे लिखो असेस, एग्जामिन, असेस और इवैल्यूएट. लिखो नंबर वन, what? Judicial review is the power of higher judiciary. Write down higher judiciary. Judicial review is the power, it is the power, it is the power of higher judiciary to examine, assess or evaluate. Number one, legislative enactments. Legislative enactments of the parliament and state legislatures. And subordinate legislation. By executive. Subordinate legislation is a power conferred by parliament to executive to make rules, orders, directions. Okay? Now this is very important concept, subordinate legislation. Okay? I am going to discuss this in detail while I discuss parliament, but remember what is subordinate legislation. देखिए, parliament does not have time to make laws providing every minute detail within the law itself. Parliament does not have time, neither it has expertise. So what parliament do, you know, parliament makes laws in a skeleton framework, in a skeleton form. It only gives the framework of law, basic frameworks of within the laws, and then it will live, or it will empower, or it will delegate. Subordinate legislation is also called as delegated legislation. After giving the basic framework of the law, parliament will delegate the power of framing rules, giving directions, orders, notifications, etc. on the basis of the law passed by the parliament to the executives. सो आपने देखा होगा पार्लियामेंट पहले लॉ बनाता है और उसके बाद में पार्लियामेंट एग्जीक्यूटिव को कहता है कि इस लॉ के हिसाब से आप नोटिफिकेशन, रूल्स, ऑर्डर्स इशू करो, क्योंकि हमारे पास इतना समय नहीं है। हम सिर्फ आपको एक लॉ बना दे रहे हैं, बेसिक फ्रेमवर्क दे रहे हैं, बाकी चीजें आप करो। डेलीगेट, सो सबऑर्डिनेट लेजिस्लेशन इज द पावर ऑफ पार्लियामेंट टू डेलीगेट the power of framing rules, issuing orders, notifications, directions, etc. by the executive. तो इसलिए आपने देखा होगा Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act was passed in 1989, and then thereafter Government of India or executive issued Scheduled Caste and Scheduled Tribes Prevention of Atrocities rules. Environment Protection Act was passed, and thereafter executive have issued environment protection rules, right? So that is called as subordinate legislation. Got it? Basic concept समझ में आया? ठीक है? It is also called as delegated legislation. हाँ बोलिए. Why you are asking this question? That is not relevant in this context, no? It was passed in 1986, but that is not relevant. हाँ, तो वो आप वो इन्वायरमेंट में देखो, ठीक है? अभी यहाँ पे कॉन्सेप्ट क्या है, क्या डिस्कस कर रहे हैं हम लोग? सबऑर्डिनेट लेजिस्लेशन डिस्कस कर रहे हैं। हाँ, उसमें कब क्या पास गया है वो छोड़ दो, ठीक है? राइट? सो सब एंड वेरी इंपॉर्टेंट कॉन्सेप्ट। सो जुडिशियल रिव्यू, क्या लिखा आपने? द जुडिशियल रिव्यू इज द पावर ऑफ हायर जुडिशरी टू एग्जामिन, असेस एंड इवेल्युएट, नंबर 1, द लेजिस्लेटिव इनैक्टमेंट्स, कॉमा, एंड सबऑर्डिनेट लेजिस्लेशन, ठीक है? नंबर 2, and executive orders, और इसमें क्या लिखोगे? और एडमिनिस्ट्रेटिव एक्शंस ऑफ एग्जीक्यूटिव। चलो, जुडिशियल रिव्यू इज द पावर ऑफ हायर जुडिशरी टू एग्जामिन, असेस और इवेल्युएट द लेजिस्लेटिव इनैक्टमेंट्स एंड सबऑर्डिनेट लेजिस्लेशन एंड एग्जीक्यूटिव ऑर्डर्स। दिस इज व्हाट इज द फर्स्ट पार्ट ऑफ जुडिशियल रिव्यू। नाउ एग्जामिन करेगा, जो पार्लियामेंट ने लॉ पास किया है, स्टेट लेजिस्लेचर ने लॉ पास किया है, वो एग्जामिन करेगा। एग्जीक्यूटिव ऑर्डर्स इशू की है, ऑर्डर, डायरेक्शन, नोटिफिकेशन, उसको एग्जामिन करेगा। नाउ इन व्हाट कॉन्टेक्स्ट इट विल एग्जामिन? It will examine, judiciary will examine in the context of whether such legislative or executive actions are in consonance with or are in accordance with the provisions of constitution or not. So basically the judicial review is the power of higher judiciary to examine, उसमें अब एक word add करो. The judicial review is the power of higher judiciary to examine the constitutional validity फिर बाद में of legislative enactment, subordinate legislation and this, ठीक है? I deliberately omitted this term, constitutional validity, ठीक है? Judicial, again, now see, I am going bits by bits. Why? Because then you this concept enters into your head, okay? So judicial review is the power of higher judiciary to examine what? Constitutional validity of what? Of actions of legislature and executive, okay? Now write down next. On examination, if on examination if they are found to be on examination, if they are found to be violative of the constitution, ब्रैकेट में लिखो ultra virus. Ultra virus means something which is violation of the constitution. That is called as ultra virus. ये term आपने बहुत बार सुना होगा. What is the meaning of the term ultra virus? Something which is violation of the constitution. On examination, if they are found to be violation of the constitution or ultra virus, then they can be declared as then they can be declared as then they can be declared as they can be declared as what? They can be declared as unconstitutional, illegal, invalid, unconstitutional, illegal, invalid और null and void. ये भी टर्म आपने बहुत बार सुना होगा. null and void means invalid. ठीक है. On examination, if they are found to be violative of the constitution, that is ultra virus, then they can be declared as unconstitutional, illegal, invalid or null and void. That is what a judiciary means. That is what judicial review means. So judicial review is power of whom? Higher judiciary. Okay? To examine what? Constitutional validity. Of what? Actions of legislature and executive alone and not of judiciary. Okay? And on examination, if such legislative actions, laws passed by the legislature or actions of executive, okay, whatever they may be, okay, if they are found to be violative of the provisions of the Indian Constitution, then they can be declared as unconstitutional, illegal, invalid, null and void. This is what judicial review means. अब आया समझ में? I know, I remember that I have taught this concept, but again, it is very important to understand again. Okay? Now here we know that judiciary is not included within the power of judicial review, meaning judiciary cannot examine its own actions by using its power of judicial review. It can do so by using other powers. Okay? Fine. Now this is what judicial review means. Now, why do we need judicial review? What is the importance of judicial review? Or what is the significance of judicial review? कोई बताएगा? To significance of judicial review. See, that is separation of powers. Okay? So what is the significance of judicial review, or why do we need judicial review? Why does higher judiciary should enjoy power of judicial review? This is a very important question, right? Number one. What is judicial review? Judiciary can examine the constitutional validity. Now, why constitutional validity has to be seen? Why every law passed by the legislature and why every administrative action of the executive should be in accordance with the provisions of the constitution? Why? Why? Because constitution is the supreme and fundamental law of the land. No authority whatsoever in India is over and above the constitution. Every branch of government, legislature, executive, as well as judiciary, they derive their powers and authority from the constitution. So if you allow the executives and the legislature to violate the provisions of the constitution, what will happen to the supremacy of constitution? Will constitution remain supreme then? No. So first and foremost reason for having this power of judicial review is to uphold the principle of supremacy of the constitution. Right? Okay? So if you do not allow judiciary to examine the constitutional validity of the legislature and the executive, then executive and legislature will do whatever they want to do. And if they are empowered to do whatever they want to do, what will happen to the supremacy of constitution? Constitution will no longer remain the supreme. But we know that in India it is the constitution that is supreme, and not the judiciary and not the parliament. Okay? So first and foremost reason for having the power of judicial review, the importance of judicial review, is to uphold the principle of supremacy of the constitution. First. Second reason why we need judicial review is to maintain federal equilibrium. Federal equilibrium, as in balance between what? Center and state. Center and states, plural states. Center is one. Okay. Ajay Singh, Ram Ram, Vanakkam, Sat Sri Akal. All right. So second is to maintain the federal equilibrium, which is provided in the Indian Constitution. See, Supreme Court of India has original jurisdiction to adjudicate the disputes between the center and states. It has original jurisdiction, meaning no other court can they can exercise the power of adjudication of disputes between center and state. It lies exclusively, originally, to the Supreme Court and Supreme Court alone, not even high courts. Okay? Right? So the power of judicial review is also important to maintain the federal balance, maintain the federal equilibrium provided in the Indian Constitution. If you do not have power of judicial review, then it will disturb the federal equilibrium. The centers might become too powerful, or states might secede from the federalism. So we need to maintain the federal equilibrium. Then only we can pursue growth, development, and whatever are the objectives enshrined in the Constitution and preamble, to be specific. Right? So that is why we need. This is the second reason why we need judicial review. Third, and the most important, we can change the sequence. We can write this third in the second. To protect the fundamental rights of the citizens. To protect fundamental rights of citizens. If you allow legislature or executive to take away your fundamental rights, then is it okay? Right? Now, but there might be instances wherein legislature might pass any law which might take away your fundamental rights. There might be instances wherein executive might pass any order, or it might take any administrative action which might violate your fundamental rights. So you should have some alternative, some remedy to prevent this violation of fundamental rights, and that remedy is power of judicial review. You can directly approach the Supreme Court to enforce your fundamental rights if they are violated, not only by the legislature but also by the executive. कल जाके गवर्नमेंट ऑफ इंडिया ने एक ऑर्डर निकाली कि कोई घर से बाहर नहीं निकलेगा. 5 स्टेट में वोट्स है, सिर्फ जो बीजेपी के सपोर्टर है वही वोटिंग में जाएंगे. बाकी लोग घर में बंद बंद रहेंगे, निकले तो शूट टू किल. Does it violate fundamental right? Yes. Freedom of movement, freedom of action, freedom of expression. So you can directly go to the Supreme Court, and Supreme Court will use what? Its power of judicial review, which is conferred under Article 32, and will prevent the executive from implementing that order. Once the judiciary examines the constitutional validity of actions of legislature and executive, and on examination, if it finds such actions of executive and legislature as violative of the constitution, ultra vires, then such actions of executive or legislature, they cannot be enforced whatsoever. They cannot be implemented. And if legislature and judiciary will go ahead, even after judiciary have declared that unconstitutional, then that will called as contempt of court, which is a criminal offense. आया समझ में? ठीक है, right? So these are the three reasons for which we need power of judicial review. Power of judicial review is important. Number one, to uphold the principle of supremacy of the constitution. Number two, to protect the fundamental rights of the citizens conferred by Part 3 of the Indian Constitution. Number 3, write down this third, maintain the federal equilibrium. Without power of judicial review, all these three are not possible. Right? So when it comes to fundamental rights, it is the higher judiciary, or the Supreme Court to be specific, which is the final interpreter of the Constitution. It is the Supreme Court which is the protector of the fundamental rights of the citizens, or guarantor of the fundamental rights of the citizens, and that is why it need judicial review, power of judicial review, to protect your fundamental rights, along with the other two reasons. Got it? समझ में आया? Fine. Now we can divide the power of judicial review into three categories. Okay, three heads. Number one, judicial review of, number one, we can classification of judicial review. Write down classification of judicial review. Number one, judicial review of constitutional amendments. Number one. Number two, judicial review of legislative enactments. Of parliament and state legislature. ठीक है? Third, what? Third क्या आएगा? Constitutional amendment का judicial review. First, classification. Second, judicial review of legislative enactments of the parliament and state legislature. यहाँ पे subordinate legislation या delegated legislation भी आएगा. ठीक है? Right? मतलब क्या? पार्लियामेंट ने लॉ पास किया और एग्जीक्यूटिव ने जो ऑर्डर या रूल्स बनाए वो उस लॉ के हिसाब से नहीं है. लॉ कुछ और कहता है, रूल्स कुछ और बनाए हैं, देन दैट विल बी डिक्लेयर्ड एज इनवैलिड, बिकॉज जो पार्लियामेंट ने जो लॉ बनाया है उसके हिसाब से ही एग्जीक्यूटिव ने रूल्स बनाने हैं. ठीक है, राइट? व्हाट विल बी द थर्ड? कॉन्स्टिट्यूशनल अमेंडमेंट्स हो गए, वो भी लॉ ही होते हैं, एक्ट्स ही होते हैं. दूसरा, अगेन लॉज of the parliament, and what is the next? What is the next? Laws हो गए, executive action. Yes. Executive orders. Judicial review of, यहाँ पे लिखो, judicial review of executive orders of both central and state governments, right? क्या judiciary will use power of judicial review to examine the laws passed by parliament alone, or the actions of only central government, executives of the central government? No, state government as well. ठीक है, समझ में आया? ठीक है. इसमें आएगा administrative actions. इसमें लिखो judicial review of executive orders of both central and state government और एडमिनिस्ट्रेटिव अथॉरिटीज अंडर द स्टेट. ठीक है, तो आप अगर IAS ऑफिसर हो, कलेक्टर हो, आपने कोई ऑर्डर इशू किया, नोटिफिकेशन इशू किया, उसको भी जुडिशियल रिव्यू, और वो अगर कॉन्स्टिट्यूशन के प्रोविजंस को वायलेट करता है So judiciary can examine the constitutional validity of that particular thing. That is called as, so no administrative authority, no legislature, no constitutional amendment act can violate the provisions of the constitution. Because if they violate the provisions of the constitution of India, then they will be challenged in the Supreme Court or the High Court. And Supreme Court will examine whether they really violate the provisions of the Indian constitution or not. And if on examination, if it finds that yes, they violate the provisions of the Indian constitution, then Supreme Court will declare such actions of executive or laws of the parliament or such constitutional amendment acts as unconstitutional, invalid, illegal, null and void. That is what Supreme Court did in 99th Constitutional Amendment Act, judicial review of constitutional amendments, judicial review of various laws, and judicial review of executive actions. These are the three, we can classify judicial review into three categories, just for the sake of understanding. Okay? Now, one important thing I told you, but I repeat again, the term judicial review is nowhere mentioned explicitly in Indian Constitution. But unlike US Constitution, Indian Constitution explicitly confers the power of judicial review to both Supreme Court and 25 High Courts. Right? So there are various provisions of the Indian Constitution which confer power of judicial review to the Supreme Court and High Court. Write down these articles. Write down quickly. I'll tell you only important articles. Okay? Article 32. Okay? Article 32. Then article, what is Article 32? Right to constitutional remedy. Okay? Then Article 226. Next, constitutional provisions. Okay? We are discussing constitutional provisions. Article 13, very important. Article 13. Article 13. Article 32. Right to constitutional remedy. If any of the fundamental rights are violated, then the citizen, they can directly approach the Supreme Court. And Supreme Court will use power of judicial review to enforce your fundamental rights. Article 32, Article 226. The same power is given to High Courts. Okay? So if your fundamental rights are violated, you have option whether to go to High Court or you can directly approach the Supreme Court. Not necessarily by appeal from the orders of High Court. You can directly approach the Supreme Court. Okay? Article 13. What is Article 13? We are going to discuss basic structure doctrine after this lecture in the next class. But what is Article 13? Article 13 states that state shall not make any law that takes away or abridges any of the fundamental rights conferred by Part 3 of the Indian Constitution. And any law passed by the state in contravention of this rule will be declared as null and void to the extent of such contravention. That is what Article 13 states. I repeat, Article 13 states that state shall not make any law that takes away or abridges or curtails any of the fundamental rights conferred by Part 3 of the Indian Constitution. And if state passes such law, any contravention of this particular rule, okay? If state passes such law, then such law to the extent of such contravention will be declared as ultra vires, or it will be declared as unconstitutional and null and void. That is what Article 13 is. So if your fundamental rights are violated, if state passes any law which violates your fundamental rights, then judiciary can use its power of judicial review under Article 13 and will declare such laws as unconstitutional and invalid to the extent of such contravention. It might happen that some of the provisions of law, only some of the provisions of law violate your fundamental rights, but the other parts of the law, they are absolutely okay. So only those provisions of the law which contravenes your fundamental rights, they will be declared as null and void, and not the entire law. Article 13. Okay, next. Article 32. Article 32. Article 131. Article 132. Article 131. Write down. Article 131. Article 132. 133. 134. 134A. 135. 136. 143. 226, etc. Don't try to remember all these articles, but just write down. So there are many provisions of the Indian constitutions which empower the higher judiciary of power of judicial review. ठीक है, right? सबसे important कौन कौन से है? Article 13, Article 32 और Article 226. ये तीन सबसे important है. ठीक है, right? Provisions. ठीक है. Now let us discuss about the term supremacy of the Indian Constitution. ठीक है, और before that let us discuss about the scope of judicial review. What is the scope of judicial review, or when the power of judicial review can be used by the Supreme Court or High Courts? ठीक है, number one. Very simple. If the actions of executive or legislature violate the fundamental rights of the citizen. If actions of executive and legislature violate fundamental rights. Actions of executive means executive orders, directions, notifications. Actions of legislature means laws, enactments, so on and so forth. ठीक है, right? Number one. ठीक है. Second, so judicial review will be used. The power of judicial review will be used if the laws passed by the legislature or actions of the executive, administrative actions of the executive, violate any of the fundamental rights conferred by Part 3 of the Indian Constitution. Number one. Second, if it is outside the competence, it is outside the competence of authority which frames rules, laws, orders, etc. Now let me give you an example. 7th schedule of the Indian Constitution provides for 3 lists. Union list, list 1 union list, list 2 state list, list 3 concurrent list. Union list has 98 subjects. Originally it had 97 subjects. State list currently has 59 subjects. Originally it had 66 subjects. And concurrent list has currently 52 subjects. Originally it had 47 subjects. Now according to Article 246 of the Indian Constitution, Parliament has exclusive power to make laws on any of the matters enumerated in the Union list. So suppose state legislature passes any law on the matter enumerated in the union list. If the state legislature passes any law on the subject mentioned in the union list, then it means that it is outside the competence of that legislature. Why? Because this power exclusively belongs to the parliament, right? Only parliament can make laws on the subjects enumerated in the union list. Defense, finance, right? So on and so forth. तो अगर स्टेट लेजिस्लेचर यूनियन लिस्ट में कोई लॉ पास करता है सब्जेक्ट में, यूनियन लिस्ट के सब्जेक्ट में, तो इट इज आउटसाइड द कंपिटेंस ऑफ दैट लेजिस्लेचर. वो कर ही नहीं सकते. 7th शेड्यूल 246. सो दैट विल बी डिक्लेयर्ड एज इनवैलिड बाय यूजिंग जुडिशियल रिव्यू. समझ में आया? नेक्स्ट, या कोई आप डिस्ट्रिक्ट कलेक्टर हो, आपने कोई ऑर्डर इशू किया, लेकिन वो आपके पावर में आता ही नहीं है. वो ऑर्डर इशू करने का आपके पास वो पावर ही नहीं है. इट इज आउटसाइड द कॉम्पिटेंस of you don't have that power and still you have issued, so judicial review. समझ में आया? Right? Third, right? So first is to protect if actions of executive and legislature violate the fundamental rights. Second, if it is outside the competence of authority which frames rules, laws, orders. And then if the actions of legislature and executive are repugnant or they violate the provisions of the constitution. Yes, if legislature passes any law or if executive issues any order, direction, notification, etc., and if such laws or such orders, if they are in violation of the provisions of the constitution or they are repugnant to the provisions of constitution, then the judicial review will be used. So this is the scope of judicial review. These are the 3 instances in which the judicial review will be used. The power of judicial review will be used. ठीक है? Right? Now, importance of judicial review, I already told you that in India it is the constitution which is supreme, and no authority whatsoever, be it prime minister, be it president, be it any political party, be it any branch of government, executive, legislature, as well as judiciary, no one is over and above the constitution. Constitution is the supreme and fundamental and paramount law of the land. No authority whatsoever, district collector, you are not above the constitution. Constitution is over and above you. It is the constitution which is supreme. No branch of government, executive, legislature or judiciary, they are over and above the constitution. Why? Because from where they derive their powers. If you become district collector, from where you will derive your power? From the constitution. So how can you go against the constitution? आपका power का source ही constitution है. So you cannot use that power, your power, against the constitution. So no branch of government can use its power in violation of the provisions of the constitution. जो भी एग्जीक्यूटिव करेगा, एग्जीक्यूटिव में आप आओगे, डिस्ट्रिक्ट कलेक्टर्स एग्जीक्यूटिव, परमानेंट एग्जीक्यूटिव, मिनिस्टर्स, प्राइम मिनिस्टर, प्रेसिडेंट, एग्जीक्यूटिव, लेजिस्लेचर, जुडिशरी, ऐसी कोई भी चीज नहीं करेगा जिसके वजह से, ऐसा कोई भी एक्शन नहीं लेगा जिसके वजह से कॉन्स्टिट्यूशन के प्रोविजंस को वायलेट हो रहा है. क्यों? क्योंकि ये सब जो अथॉरिटीज है ना, ये अपनी पावर डिराइव करते हैं कॉन्स्टिट्यूशन से. और कॉन्स्टिट्यूशन पावर डिराइव किससे करता है? व्हाट इज द सोर्स ऑफ अथॉरिटी ऑफ द इंडियन कॉन्स्टिट्यूशन? वी द पीपल ऑफ इंडिया. यस, एक्सलेंट preamble. So in India, it is the constitution that is supreme. And who gave the constitution? It is the people of India. We, the people of India, have given ourselves this constitution. So in India, it is the constitution that is supreme. Why? Because it is we, the people of India, who have framed this constitution. So that is why no authority whatsoever, कितने भी powerful हो, प्रेसिडेंट हो, प्राइम मिनिस्टर हो, कितने भी उनके पॉलिटिकल पार्टी कितनी भी मेजोरिटी हो, 3/4 हो, 5, कुछ मैटर नहीं करता है. They cannot do anything if it violates, they cannot do anything which violates the provisions of the constitution. और अगर वो वायलेट करता है तो क्या होगा? Judiciary will step in. It will use its power of judicial review to declare such actions as unconstitutional, and hence they cannot be enforced, they cannot be implemented. I give you example of 99th Constitutional Amendment Act. It was passed by special majority of both the houses of parliament. Still, Supreme Court declared it as unconstitutional and void. Why? Because it violated the provisions of the constitution, the basic structure of the Indian constitution, which we are going to study in the next class. समझ में आया? Now, let us understand supremacy of the constitution. I have already taught you basically. Then, supremacy of the judiciary. And supremacy of what? Parliament. So we, India, have supremacy of the in India. What is supreme? It is the constitution is supreme. But there are other two doctrines: supremacy of parliament and supremacy of judiciary. Now, supremacy of the parliament is basically correct in the case of Parliament of UK. In UK, the principle of parliamentary supremacy is followed. In UK, who is supreme? Parliament is supreme or constitution is supreme? In UK, it is the parliament which is supreme. Why? In UK, who made whom? Parliament made the constitution or constitution made the parliament? Parliament made the constitution. Because in UK, Parliament can amend the constitution, or it can frame the constitution, it can repeal the provisions of the constitution only by simple majority. UK constitution is very flexible. So in UK, first parliament came into existence, and that parliament created the framed the constitution. So in UK, it is the parliament that is supreme and not the constitution. So supremacy of the parliament is the principle which is followed in UK. So supremacy of the parliament is UK, principle of UK. समझ में आया? Supremacy of judiciary. In USA, it is the judiciary that is supreme. It is the judiciary that is supreme. So supremacy of the judiciary is the principle followed in USA. In USA, it is the judiciary that is supreme. In UK, it is the parliament that is supreme. Now, what about India? क्या इंडिया में पार्लियामेंट सुप्रीम है? In India, parliament is not supreme. Why? Can parliament pass any law which violates the provisions of the constitution? No. And if parliament passes such law which violates the provisions of the constitution, what will happen? Judiciary will step in. जैसे 99th Constitutional Amendment Act पास किया, पास तो किया ना, जुडिशरी आ गया और इसको डिक्लेयर इनवैलिड कर दिया. बट कैन जुडिशरी ऑफ यूके डिक्लेयर the law passed by the parliament as unconstitutional and invalid? No. The power of judicial review in UK is extremely narrow. In UK, the scope of judicial review is extremely narrow. In UK, the judiciary cannot examine the constitutional validity of law passed by the parliament. It can only examine the constitutional validity of the actions of the executive only, and not the laws passed by the parliament. Why? Because it is the parliament that is supreme. समझ में आया? ठीक है? In USA, it is not the US Congress that is supreme, it is the judiciary that is supreme. Right? Supreme Court of USA is the most powerful Supreme Court in the world. In fact, the Supreme Court of USA is often referred as third chamber of legislature, or super legislature, or arbiter of social policy framed by the executive. Why? Why it is called a super legislature? Or third chamber of legislature has two chambers. USA Congress has two chambers, House of Representatives and Senate. It is argued that even judiciary or Supreme Court is the third, it is like the third chamber of US Congress. Or it is super legislature, above the US Congress. Why? Because it is extremely powerful. The scope of judicial review of Supreme Court of USA is extremely wide. Number one. Why? Because in USA it is the judiciary that is supreme. In UK, the scope of judicial review of UK Supreme Court, it is extremely narrow. Why? Because judiciary cannot examine the constitutional validity of the laws passed by the UK Parliament. It can only examine the constitutional validity of the actions of the executives or ministers. So ऐसा नहीं कि यूके में जुडिशियल रिव्यू की पावर ही नहीं है लेकिन बहुत ही नैरो है. यूएस में बहुत ही वाइडर है. नाउ व्हाई द जुडिशियल रिव्यू पावर ऑफ सुप्रीम कोर्ट ऑफ यूएसए इज एक्सट्रीमली वाइड, और व्हाई सुप्रीम कोर्ट ऑफ यूएसए इज कॉल्ड एज the most powerful Supreme Court in the world. Why? Because the Supreme Court of USA follows the principle of due process of law. Now again, this is very important concept. Why the scope of judicial review of the Supreme Court of USA is extremely wide? Why? Because it follows the principle of due process of law while interpreting the actions of executive and legislature. Okay? Now what is due process of law? The principle of due process of law. See, the principle of due process of law means, ध्यान से सुनना, इधर देखो, ये बहुत इंपॉर्टेंट है. डिफरेंस बिटवीन ड्यू प्रोसेस ऑफ लॉ एंड प्रोसीजर इस्टेब्लिश्ड बाय लॉ. आई एम गोइंग टू टीच दिस अगेन सिस्टमैटिकली व्हेन वी डिस्कस आर्टिकल 21, बट इन दिस कॉन्टेक्स्ट लेट मी ब्रीफली टेल यू व्हाट इज द डिफरेंस. सो ड्यू प्रोसेस ऑफ लॉ means the judiciary will not only look whether a proper procedure established by law is being followed by the legislature or not. While making the law, judiciary will not only examine whether the proper procedure is being followed by the legislature while framing that law or not. Right? It will examine the procedure. For example, in India, any bill can become an act, right, provided it follows certain procedure. Introduction of the bill, first reading, second reading, third reading, this procedure, right? So, while using the due process of law, it means that judiciary will not only go into the procedure, that is whether that procedure is being followed by the legislature or not, but judiciary can question the law itself. It can question the subject matter of the law, the content of the law itself. Whereas Indian judiciary follows the principle of procedure established by law. I'll tell you, procedure established by law. this has been borrowed from this principle has been borrowed in Indian constitution from Japan. Now what is procedure established by law? So procedure established by law means the judiciary will only examine whether the proper procedure as provided under law is being followed by the legislature or executive or not. अगर प्रॉपर प्रोसीजर फॉलो की है लॉ बनाने के लिए या कोई ऑर्डर इशू करने के लिए, then that will be upheld. So court, Supreme Court in India or high courts in India, they cannot go into whether the law itself is good or bad. They cannot challenge the law itself. They will only see whether the proper procedure has been followed or not, or whether the law is in accordance with the provisions of the constitution or not, or whether the legislature which has framed that law has competence, has legislative competence or jurisdiction to pass that law or not. Only it will examine that. Apart from that, it will not go into the subject matter of law itself, what is contained in the law itself. Got it? For example, APSPA, Armed Forces Special Power Act, 1958. Now this is extremely draconian law. Now Supreme Court, while examining the constitutional validity of APSPA, will look into following things. Number one, whether this law violates the provisions of the constitution or not. Now this law does not violate the provisions of the constitution, number one. Second, whether the authority which has framed this law has power, legislative competence or jurisdiction to frame law on this subject matter or not. Parliament has power to frame such laws. So Parliament has legislative competence. It has jurisdiction to pass laws on the matter of, because defense, security, right? ठीक है? Legislative competence है, constitution को violate नहीं कर रहा है, ठीक है, right? Third, if whether the due process has, whether the procedure established by law, whether the procedure provided in the law has been followed by the Parliament in enacting the APSPA. As in first reading, second reading, दोनों हाउस में पास किया ही नहीं किया है, प्रेसिडेंट का असेंट मिला ही नहीं मिला है, ये सारी चीजें हैं, सारी चीजें करेक्ट. The APSPA does not go against the provisions of the constitution. Parliament has legislative competence or jurisdiction to pass APSPA, this law. And third is what? Third, what? क्या बोला मैंने? Whether a proper procedure has been followed by the Parliament in enacting this law or not. Now all these have been, all these three conditions have been fulfilled. Then Supreme Court will not go into whether APSPA itself is bad or good. It will not go into what is contained in the law. APSPA में क्या लिखा है वो नहीं जाएंगे, उसमें नहीं जाएंगे, unless and until it is a violation of the constitution. ठीक है? So Supreme Court of India cannot declare APSPA as unconstitutional and void. Why? Because all these three conditions have been fulfilled. But अगर देखा जाए तो APSPA is extremely draconian law, wherein the army have been given power of shoot to kill. So Indian Supreme Court cannot declare. Why? Because it follows the principle of procedure established by law. But in case of US, the Supreme Court will not only go into the procedure, whether the procedure has been followed or not, but it will also go into whether the law itself is good or bad, whether the law itself is reasonable, fair or not, whether the law is arbitrary or not. If the Supreme Court of USA finds the law itself as unfair, arbitrary or unreasonable or unjust, then it can declare the law itself as invalid, irrespective of whether the procedure has been followed or not. समझ में आया? Right? So procedure established by law, principle of procedure established by law means that the judiciary will only go into whether the procedure followed under the procedure established under the law has been followed by that authority or not. जैसे पुलिस ऑफिसर्स को किसी को अरेस्ट करने का अधिकार है, पावर है, ठीक है। अब वो जब अरेस्ट करते हैं तो उस अरेस्ट करने के लिए एक प्रॉपर प्रोसीजर दी गई है, कॉन्स्टिट्यूशन में भी दी गई है और सीआरपीसी में भी दी गई है कि जब पुलिस ऑफिसर किसी व्यक्ति को अरेस्ट करेगा तो अरेस्ट मेमो साइन करना चाहिए। ही शुड बियर एन विजिबल डेजिग्नेशन, उसका डेजिग्नेशन होना चाहिए, यहाँ पे क्लियर होना चाहिए। जब वो अरेस्ट करेंगे तो उसको बताना चाहिए कि फॉर व्हाट रीजन ही इज बीन अरेस्टेड, ठीक है, राइट। उसको 24 घंटे के अंदर नियरेस्ट मैजिस्ट्रेट के पास लेके जाना है। तो ये सारा प्रोसीजर प्रॉपर फॉलो करना है, और अगर इस प्रोसीजर को फॉलो नहीं किया तो ड्यू प्रोसीजर एस्टेब्लिश बाय लॉ का यूज करके वो अनकॉन्स्टिट्यूशनल डिक्लेयर किया जा सकता है। बट सारा प्रोसीजर फॉलो किया है अरेस्ट करते समय, तो वो आपका अरेस्ट इटसेल्फ विल नॉट बी डिक्लेयर्ड एज अनकॉन्स्टिट्यूशनल। समझ में आया, ठीक है। सो प्रोसीजर एस्टैब्लिश्ड बाय लॉ means judiciary will only look into whether the proper procedure has been followed by the legislature in framing that law or not, and along with that it will also go into whether the law is in consonance with the provisions of the constitution or not, and third is whether the legislature which has framed that law has jurisdiction to frame that law or not, whether it has legislative competence to frame that law or not. If these conditions are fulfilled, it will not go into whether the law itself is good or bad, whether the law itself is reasonable, arbitrary or fair or not. Judiciary will not go into that subjective matter, no, कि law खराब है, law ऐसा है, नहीं. So US, whereas in case of USA Supreme Court, it can go into the subject matter of law. It can declare whether the law itself is fair. It can look into whether the law itself is fair, arbitrary or unreasonable or not. समझ में आया? So US, so in USA the Supreme Court is extremely powerful. Why? Because the Supreme Court of USA follows the principle of due process of law, whereas the Indian Supreme Court follows the principle of procedure established by law. ठीक है? And in USA it is the judiciary that is supreme. ठीक है? Right? So let us discuss about what in case of India. So in UK it is the parliament that is supreme. In USA it is the judiciary that is supreme. In India, is the parliament supreme or whether the judiciary is supreme? No. The Indian constitution follows the synthesis between the principle of parliamentary supremacy and the principle of judicial supremacy. Indian constitution provides for balance between the UK principle of parliamentary supremacy and US principle of judicial supremacy. जैसे UK constitution is flexible, US constitution is rigid, Indian constitution is a proper synthesis between rigidity and flexibility. Similarly, in India follows the Indian constitution is based on the synthesis of the US principle of judicial supremacy and UK principle of parliamentary supremacy. In India, it is not the judiciary that is supreme. In India, it is not the parliament that is supreme, as in case of UK. In India, it is the constitution that is supreme. Got it? Now, why in India parliament is not supreme? I told you in UK parliament is supreme. It is said that UK parliament can do anything except making women a man and man a woman. It is extremely powerful. Parliament of UK is the most powerful parliament in the world. Supreme Court of USA is the most powerful Supreme Court in the world. In India, we have balance between both. Now, why in India? Yes, in India, it is the constitution that is supreme, not the judiciary and not the parliament. No, we cannot say that. We cannot say that Indian constitution is the best constitution in the world. No constitution is the best constitution in the world. Every constitution has its own strengths and weaknesses. Right? There are some good things in every constitution. There are some weaknesses in every constitution. क्या? What? How? Every constitution is supreme, beta. Every constitution is powerful document. It's a powerful document. You cannot see. Don't go into these hypothetical things. Ki कॉन्स्टिट्यूशन इज द मोस्ट पावरफुल डॉक्यूमेंट इन द वर्ल्ड इन इंडिया, ऐसा नहीं है, ऐसा नहीं है. डोंट गो इनटू दैट. When it comes to institutions, you can say whether they are powerful or not. When it comes to constitution, you cannot say. ठीक है, समझ में आया? राइट. सो बाइनरीज में मत करो कि ये पावरफुल है, ये नहीं है, ये बेस्ट है, ये बाइनरीज को डिवाइड मत करो. ये कॉन्सेप्ट्स है, कॉन्सेप्ट्स को समझो. ठीक है, राइट. नाउ व्हाई इन इंडिया पार्लियामेंट इज नॉट सुप्रीम? नाउ इन इंडिया द सुप्रीमेसी ऑफ द पार्लियामेंट is limited. Can parliament pass any law? No. Right? So supremacy of the parliament in India, it is constrained or it is restricted by following factors. Number one, write down. Why in India parliament? What are the factors that limits the supremacy of the parliament in India? Number one, because we have written constitution. We have written constitution. UK parliament supreme है क्यों? Because UK has unwritten constitution. ठीक है? Number second, we have federalism. Federalism with distribution of power between center and state. Between center and state. Sharad Gupta, I am great. Nobody is great. No constitution is best. Every constitution has its own strengths and weaknesses. So no person is great. Okay? Every teacher has its own strengths and weaknesses. I have my strengths, but I have my own weaknesses as well. And I accept that, Sharad. But anyways, thank you for your response. Federalism with distribution of powers between center and state. That limits the power of parliament. Can parliament make laws on the matters enumerated in the state list in ordinary circumstances? Nahi. In exceptional circumstances, parliament can make laws on the subjects enumerated in the state list, but in ordinary circumstances, parliament cannot make laws. So that federalism along with distribution of powers between center and state limits the supremacy of the parliament in India. First, written constitution, because parliament cannot make any law which violates the constitution itself. So having written constitution limits the power of parliament. In UK, there is no written constitution. So there are no limitations on the power of parliament whatsoever in UK. But in India, we have written constitution, we have federalism with distribution of powers between center and state. Then, what else? We have then fundamental rights of the citizens. They also acts as restrictions. Fundamental rights of citizens. ठीक है? Yes? Can parliament violate the fundamental rights of the citizens? Nahi. Why? Article 13. Article 13 clause 2. State shall not pass any law that takes away or abridges any of the fundamental rights of the citizens. And any law made in contravention of this shall be null and void to the extent of such contravention. So, fundamental rights of the citizens limit the supremacy of the parliament. And fourth, the topic which we are discussing today, that also limits the power of parliament. What? Judicial review. Thank you, Sharad, and please share these videos with your friends so that they know what kind of education we provide at Siddhartha IAS. People go on the basis of views, कितने views है ना, उसके हिसाब से जाते हैं. No, don't go based on that. Views खरीदे भी जा सकते हैं, हम लोग views नहीं खरीदते हैं. ठीक है, चलो ये लो. So in India, not judiciary, India is not based on the principle of judicial supremacy and nor on the principle of parliamentary supremacy. Why in India parliament is not supreme? Because supremacy of the parliament or powers of the parliaments are limited by following factors. Number one, what? Written constitution. Federalism with distribution of powers between center and state. Third, fundamental rights of the citizens. And fourth, judicial review. Because if parliament passes any law, judiciary can declare such laws as unconstitutional if they violate the constitution. So that's why in India, parliament is not supreme. Why? Because the powers of the parliaments are limited by 4 factors. These are the 4 factors. In UK, parliament is supreme. Okay? Okay? Then, what is the scope of judicial review in UK, India, and USA? What is the comparative comparison, right? So, the scope of judicial review, the scope of power of judicial review in UK, it is extremely narrow. The scope of power of judicial review in USA, it is extremely wide. Okay? In India, the scope of judicial review, it is wider than UK, but narrower than USA. Okay? UK, extremely narrow. Okay? Power of judicial review. What about US? Extremely wide. What about India? The scope of judicial review, right? Not power. Don't write power. The scope of judicial review. ये बहुत important है समझना. Scope of judicial review. Scope of power of judicial review in India, it is wider than UK, but narrower than. Why narrower than USA? Why is it so? Why narrower than USA? Because no, good or bad wala nahi. Because the judiciary of USA follows the principle of due process of law, whereas the Indian judiciary follows the principle of procedure established by law. Got it? Clear? Good. So in next lecture we will discuss briefly the judicial review of 9th schedule of Indian Constitution. And in that we will discuss I.R. Coelho versus State of Tamil Nadu case of 2007, on which UPSC asked question in GS paper 2 mains. इसके ऊपर क्वेश्चन पूछा है, सीधे पूछा है यूपीएससी ने, व्हाट वाज हेल्ड बाय सुप्रीम कोर्ट इन आई.आर. कोएलो केस. ठीक है, एंड अबाउट जुडिशियल रिव्यू. सो जुडिशियल रिव्यू इज अ वेरी इंपॉर्टेंट टॉपिक फॉर यूपीएससी. Today we have discussed, what did we study today? We have discussed about criticisms of the Indian Constitution. Okay? And then we discuss about what is judicial review, what is the significance of the judicial review, what is the importance and significance of the judicial review. Then we have discussed classification of the judicial review, and then we have discussed the scope of judicial review, and we have also discussed about whether in India, what is judicial supremacy, what is parliamentary supremacy, what about India. Right? In India, we follow the synthesis between the principle of judicial supremacy, US principle of judicial supremacy, and UK principle of parliamentary supremacy. In India, what is supreme? It is the constitution, that is supreme fundamental law of the land. Right? All right. Thank you. कुछ questions है? हाँ. Constitution of India. इंस्टीट्यूशन अगर आप कहोगे तो ऐसा कोई इंस्टीट्यूशन नहीं है जो सुप्रीम है. क्यों? अगर आप कहते हो कि पार्लियामेंट सुप्रीम इंस्टीट्यूशन है, या इलेक्शन कमीशन ऑफ इंडिया सुप्रीम इंस्टीट्यूशन है, या सुप्रीम कोर्ट ऑफ इंडिया सुप्रीम इंस्टीट्यूशन है, इसका मतलब उसके ऊपर कुछ है नहीं. लेकिन ऐसा है इंडिया में, उसके ऊपर है, क्या है? कॉन्स्टिट्यूशन. सो नो इंस्टीट्यूशन इन इंडिया इज सुप्रीम, नो ऑथोरिटी इन इंडिया इज सुप्रीम. No branch of government in India is over and above the constitution. It is the constitution that is supreme. So you cannot say that parliament is supreme institution. You cannot say that election commission is supreme institution. You cannot say that UPSC is the supreme institution. Yes, within its own jurisdiction, it might be powerful. It can be autonomous and independent, but you cannot say that that is the supreme institution. Because supreme का मतलब क्या है? Supreme मतलब highest authority. But in India, no authority is the highest. It is the constitution which is supreme authority, and no institution whatsoever, कितनी भी अच्छा perform कर रहे हो, no institution whatsoever is over and above the constitution. Why? Because in India, it is the constitution that is supreme. Got it? All right. Thanks a lot. Thank you for those who are watching online. Keep watching, and please download the Siddhartha IAS app. And if you take the course of Siddhartha IAS, then you will get 2 GB data free every day. It's a big time offer provided by Siddhartha IAS. So please download the app, borrow the course. You can borrow the entire GS course, or you can borrow the modules as well. As in, you can borrow the Indian Polity module or Indian Economy module. Whatever you purchase, whatever course you purchase, you will get 2 GB data free every day. All right. Chalo.